Welcome back to the deep dive. Today, our mission is pretty laser focused. We are diving into a really critical, very recent decision by the Supreme Court of India.
And it's one that gets right to the heart of a constant tension in any democracy, doesn't it?
It really does. It's that line between personal freedom and, state administrative power.
Right. Can the executive branch just use bureaucratic rules to restrict a fundamental right, even when someone hasn't actually been found guilty of a crime?
Exactly. This deep dive is all about the 2025 ruling in Mahesh Kumar Agarwal v. Union of India and another, and we're looking at a situation that, frankly, a lot of people could find themselves in. You've got a pending criminal proceeding, maybe it's a complicated commercial dispute that's been dragging on for years, but you still need to travel, you have a life, a business to run. What happens then?
And the immediate fear for most people is that your life it freezes, your passport gets yanked, you're grounded, and you're just stuck waiting.
For years, maybe.
Exactly.
Yeah.
And what's so revolutionary about this judgment is that it tells the state, hold on, that big freeze button, you can't just press it automatically.
So the big question for you, the listener, is this. How far can the state really go in restricting your right to travel when you haven't even been convicted of anything?
And this ruling from Justices Vikram Nath and Augustine George Mossy is a huge victory for personal liberty. It fundamentally clarifies the scope of Article 21, especially how it interacts with the Passports Act.
Okay, let's unpack this. So before we get into the specifics of the Agarwal case itself, we kind of have to lay the groundwork. Constitutionally, where does this right to travel abroad even come from in India?
The foundation is Article 21, the protection of life and personal liberty. Now, the words right to travel abroad aren't explicitly in there,
Right.
but the courts have long understood that personal liberty is more than just not being in jail. It includes the ability to move freely, to go beyond your country's borders as part of a full life.
But that understanding didn't just appear out of thin air, right? There's a history there that really informs why this 2025 ruling is so protective.
Absolutely. You have to go back to the 60s, to the Satwan Singh Sawhney case in 1967. That's when the Supreme Court first recognized it. But, I mean, the real game changer was Maneka Gandhi v. Union of India in 1978.
Maneka Gandhi. You hear that name come up in almost any discussion about personal liberty in India. What did that case do that was so crucial for a case like Agarwal's all these decades later?
Maneka Gandhi basically introduced the principle of procedural due process to India. Before that, the government could argue that as long as they followed some kind of procedure, any procedure, it was okay.
We ticked the box, essentially.
Exactly. But Maneka Gandhi said no, the procedure itself has to be fair, just, and reasonable. Not just written down somewhere, but actually fair in practice. And that sets the stage for the whole proportionality test we see here.
Okay, so let's fast forward to 2025. Mr. Agarwal needs his passport renewed. He has a criminal case pending. The passport authority just says no. What was their legal justification for that?
Their justification, their legal hook, was Section 62F of the Passports Act, 1967. And if you just read it on its own, it sounds pretty absolute.
What does it say?
It says a passport shall be refused if proceedings for an offense are pending against the applicant in a criminal court.
The word shall sounds pretty final. It seems like an open and shut case for the passport authority. How does the Supreme Court get around that?
Here's where it gets really interesting. The court didn't just ignore Section 6.2. They said you have to read it constitutionally.
Through the lens of Article 21.
Precisely. They said 6.2F doesn't stand alone. It has to be read together with Section 22 of the Act and, crucially, with the exemption notifications the government itself had issued over the years.
So 62F is like the strict general rule, but Section 22 and these exemptions are the constitutional safety valves.
That's a perfect way to put it. This combined reading completely transforms the restriction. The passport authority wanted it to be an absolute bar. A pending case means you're permanently disabled from getting a passport.
But the court said no.
The court said no, it's a qualified restriction. And that distinction is everything.
Okay, let's break that down. What's the practical difference between a qualified restriction and an absolute bar?
An absolute bar is like a permanent red light. It's just stuck on red. You can never go.
Yeah.
A qualified restriction is more like a flashing red light,
Right.
where you can proceed if, say, an officer waves you through.
So the restriction is conditional.
It's conditional. It's subject to approval from a higher authority.
And in this case, that higher authority is the criminal court that's actually hearing the case?
Exactly. This is where the no objection certificate, the NOC, becomes so important. The Supreme Court is saying that if the criminal court, The body that knows the case best and can assess the flight risk has already looked at it and granted an NOC.
Then the passport authority can't just overrule them.
They can't. The administrative body can't just unilaterally say, we know better than the judge.
So it elevates the NOC from just a suggestion to something that's, well, almost binding on the administration. The judicial branch has done the risk assessment for you.
That's it. You can't have the passport authority acting as some kind of parallel court, second-guessing a judicial decision on flight risk.
But let me play devil's advocate for a second. Isn't the passport authority just doing its job? Protecting the state's interest? They're worried this person will get a 10-year passport and just disappear.
Of course that's their concern, and it's a legitimate one. But the court had precedents to counter that. They pointed to the strong presumption of innocence. If you look at the 2020 Vangala Kasturi Rangachar case, the court was already saying that refusing a passport should really only happen upon conviction.
So not just based on an accusation.
Right. And in another case in 2023, Gani Bhaskar Rao said again that just having a case pending isn't a good enough reason to refuse a renewal. The Agarwal ruling is really the capstone on that whole line of thinking.
Let's shift to the core principle the court used to knock down the denial: proportionality. This is where the logic really comes together.
What's fascinating here is how they use proportionality. The idea that what the state does has to be, no more intrusive than what's necessary to achieve its goal.
And the goal here was preventing him from fleeing.
Right. And the court looked at the situation and saw that the criminal court had already put strict proportionate conditions on Mr. Agarwal.
Like what, for example?
Like maybe making him deposit his passport with the court, or requiring him to get specific permission for every single trip abroad, maybe posting a bond. The judiciary had already used a scalpel to manage the risk.
I see. So the passport authority coming in with a sledgehammer and just denying the passport renewal entirely was overkill.
It was completely disproportionate. The risk was already being managed by the courts in a very specific, tailored way. This blanket denial on top of that was just unreasonable.
And this leads to that incredible phrase from the ruling about how the passport authority was assessing the risk. They weren't using facts, they were using fear.
Yes. The court said the authority cannot refuse a passport based on speculative apprehension of misuse. Such a powerful line.
Speculative apprehension. What does that signal for administrative law going forward?
It's a huge signal. It means the executive branch can't just infringe on your fundamental rights based on what they imagine might happen.
Especially when a court has already done a real factual risk assessment.
Exactly. To do so means the passport authority is trying to second-guess the judicial assessment, which is a massive overreach. The court made it crystal clear. The primary body for assessing flight risk is the criminal court hearing the case, period.
So after all of this, what was the actual tangible outcome for Mr. Agarwal? What did the court order?
So what does this all mean? Well, the Supreme Court's final order was very direct. They set aside the High Court's decision and ordered the regional passport office to reissue the passport.
And not just for a year or two, right? They were specific about the duration.
That's a massive detail, yes.
Yeah.
They ordered it be reissued for the standard 10-year duration. This is a huge rebuke to that common practice of giving people in this situation a short-term passport, forcing them to come back and beg every year.
It stops the state from using administrative hassle as a kind of punishment before conviction.
It does. It validates the document for the full period.
But, and this is the crucial balance, getting that 10-year passport doesn't mean Mr. Agarwal can just book a flight tomorrow and leave, does it?
Absolutely not. And this is where the solution is so elegant. While the passport authority has to issue the document, the court was very clear that the criminal court keeps total control over his actual travel.
So he still has to go to the judge and ask for permission for specific trips.
Every single time. The passport is just the document he needs to be able to travel. The permission to actually go still comes from the judiciary.
It's a perfect separation. The administrative right to hold a valid passport is restored under Article 21, but the judicial power to control movement to ensure justice is fully maintained.
It reinforces the whole structure. It tells every administrative body that, your discretion ends where judicial authority and fundamental rights begin. Any restriction has to clear that high bar of proportionality that goes all the way back to Maneka Gandhi.
The big takeaway seems to be that presumption of innocence isn't just a nice idea. It has real practical consequences for how the state has to treat you.
It does. And it raises a really interesting final question. The court was so firm here in rejecting administrative fear. So you have to wonder, how does this ruling raise the bar for the state to justify restricting other personal liberties? That's something for you to mull over as we see these principles start to get applied in other areas of law in the years to come.